welcome to May's Midweek Matters. We are exploring employment and we have the pleasure of having Samantha Castle joining us. Samantha is an employment lawyer from Barking and Kirby. She started working with them in 2006 and qualified as a solicitor in 2008. She's got a vast amount of experience in both employment law cases and in personal injury claims. In 2017, she won the Bristol Law Society's Lawyer of the Year, congratulations, and was promoted to partner in 2018. In her employment role, Samantha deals with both employee and employer matters, including drafting contracts and policy documents, providing human resources advice, dealing with redundancies, drafting and advising upon contracts and settlement agreements, and dealing with unfair and constructive dismissal claims, discrimination cases and complex tribunal matters. She's also a member of the Employment Lawyers Association. Samantha, I'd like to welcome you to Midweek Matters this evening and thank you so much for sharing with us your knowledge, experience and providing a space for us to ask our questions. Welcome.
Oh, thank you so much for having me. Right, I'm going to be all tech savvy now and share my screen, so bear with me. And then I'm hoping everyone will be able to see that. Is that the case?
Yeah.
And then I should be able to. Can you see, if I scroll through, can you see the second slide? Or can you just see?
If you just go from if you press from the beginning at the top.
Let me stop. I think I've chosen the wrong screen. Bear with me a second. So you can just see that, can't you? As I go through. Weirdly, I've got another screen that's got something else. So let me try and pick that one up.
Yes.
Okay, so if I scroll through, you can see that, I'm hoping, as I scroll through. Yeah, fantastic. Let me. Oh. We said about technology being not on our side today. Let's just try that again. So I had it all ready to go, and then if it doesn't work this time, we will just go with the fact that you can see the slides. I think that makes life easier. That feels like a proper slideshow now I'm seeing. So sorry about that, but thank you so much for having me. I mean, I know the charity aims to provide information and education in order to empower and give a voice to the adult cerebral palsy community. So I hope my small contribution will help towards this today. So thank you so much for the introduction. As Miriam said, so my name is Samantha Castle, Sam, and I'm a partner at Barking and Kirby Solicitors. And yeah, so I head up our personal injury and our employment law team. So I do the two areas of the law. Within my personal injury role, I work closely with our clinical negligence colleagues. And so I've seen firsthand how our solicitors support and assist people with cerebral palsy. So I have had involvement and dealings with providing guidance and advice from an employment point of view to those clients. And like is with my employment law hat that I'm going to speak to you today to discuss the challenges of employment with a disability and knowing your rights in the labour market and the workplace. As I said, Barking and Kirby, I've been with the firm for a fair old while, since 2006. So we're a firm of solicitors who pride ourselves on providing kind of effective and efficient, clear legal solutions whilst being friendly and approachable. And we've got 5 offices around Bristol and South Gloucestershire, and I'm based in the centre of town. So we provide individuals and businesses professional legal advice. But I understand from the focus of the Midweek Matters in May, it's all about how the world of work can be made more accessible to members of the CP community and how you can forge your own path. And, you know, so I'm helping my talk, as I said, will add to this information piece. Getting in, staying in and progressing in employment is often challenging for someone with a disability. And whilst there's amazing organisations out there, and, you know, I was looking on the websites, kind of Even Break, which Miriam mentioned to me previously, but also Clear Talents, and careers with disabilities, to just name a few. But I think my talk, obviously given my role, is more from a legal point of view as to what obligations and duties employers have to support people, their workers with disabilities. And I admit this is the first time I've done it from this angle. So I've done a similar kind of talk for employers. So I work alongside sometimes CIPD, which is a HR professional body. So I provide them talks on what they need to do and what is expected of them as employers. So like I said, I hope I can kind of flip that on its head and give you information about what you should expect from your point of view. And I wanted to kind of cover the different stages of the employment. So recruitment, so when you see the job ad, the interview and assessment process. You know, I know people worry about when to disclose sometimes when people have a disability, and also the issues that may arise during the employment. So reasonable adjustments being a big thing, a big topic, and that can include things like flexible working arrangements. So as we said, I'm more than happy to take questions throughout. You know, it's always that, don't feel like you missed the moment, just get in the chat, raise your hand, or however best you wish to communicate. And I understand the chat functions being monitored, so just feel free to interrupt me as in when. So yeah, that's kind of the introduction part. And then from my point of view, the starting point is the Equality Act 2010. So this came into force in October 2010, and it brought together over 116 separate pieces of legislation into one single act. And it sets out the personal characteristics that are protected by law and the behaviour that is unlawful in relation to that. So as I said, today we're going to be focusing solely on the protected characteristic of disability. And when a recent survey, 1 in 5 people in the UK have said they've got a disability. That's like nearly 40 million people. So employers have to know their obligations under the Equality Act to ensure they don't fall foul of any kind of discrimination claim that they may face. So when I'm looking at the Act, I go straight back to the basics. So Section 8 sets out the definition of what is a disability, as I said on the screen. So a person has a disability if they have a physical or mental impairment, which has a substantial and long-term adverse effect on their ability to carry out normal day-to-day activities. So it's got to be kind of more than minor, more than trivial, it's got to be substantial. And the kind of case law that comes around this suggests that the kind of long-term bit tends to be 12 months, or it's reasonably foreseeable in the future. And if you meet those criteria, you're likely to be protected from discrimination on the basis of the disability under the Equality Act. And every case is so individual. But if you look at that definition, you go back to basics, look at that, and then you can go through that will give you a good starting point. I mean, the law recognises that bringing equality for disabled people means changing the way potentially that the employment is structured, the removal of physical barriers, and or providing extra support for a disabled worker. So this duty to make reasonable adjustments is what I'll be going into detail with during the talk, but it's a unique duty specifically in relation to disability. So it's not a case of this would apply to someone who is older and we're talking about age or something that is a religious belief. It's specifically in relation to disability. So essentially, the law aims to support disabled workers, including making reasonable adjustments, as well as protect them from disability discrimination, victimisation or harassment. Okay, so we'll look at the kind of individual ones, but essentially direct discrimination is when someone's been treated less favourably than a non-disabled person because of their disability. Indirect discrimination is where there's things in place, policies, processes, workplace practices that apply to all employees, but places a disabled person at a distinct, unjustifiable particular advantage compared to their peers. And also, as I said, kind of harassment and victimisation where you feel you've been targeted as a result of your disability. So an employer can,
Sorry, Samantha, I was just wondering if I could just ask you to explain the second
Indirect.
indirect. Yeah.
Yeah.
How would that represent itself? Because sometimes it feels like it's a little bit difficult to define.
Yeah, so I mean, I suppose the classic one that I tend to see more regularly in my line of work is sick pay and also absences kind of policies. So where the work's got a policy where they have like one uniform absent policy where, you know, 3 strikes you're out. So you hit 3 trigger points on your absence for absences on the policy, and they say, right, you've got 3 strikes, that means you get an informal warning, you get another strike, you've got a formal warning, another strike, you're out, basically. You can no longer do the job because you've breached this absence policy. And so it's called a PCP. But essentially that policy is classed as discriminatory because there's no adjustments made for the fact that someone who's disabled is likely to have more time off work than they may need to. Or it might be that, you know, they talk about appointments, that they may need to go to appointments, and there's this really uniform policy that doesn't really have any discretion. I find policies that don't have discretion could fall under the indirect discrimination because there's got to be that leeway and allowance to look at an individual's circumstances. Same with sick pay. You know, you say, okay, you don't get paid sick pay after that. It might be that it's reasonable to pay more sick pay because of the reasons why you're off work. I hope that gives a decent example.
Brilliant.
Anyway.
No, that's really helpful.
Yeah.
Thank you.
No, that's great. No, like I said, yeah, interject. That's great. Thank you so much. So, I mean, if an employer falls foul of these kind of duties and obligations under the Equality Act, essentially, you may have an employment tribunal claim against them. And people are much more scared, employers are much more scared of discrimination claims than any other claims because they are not capped in terms of the compensation that can be awarded. So if you are sacked from work for unfair dismissal, and it isn't something to do with a protected characteristic, so it's nothing to do with disability, nothing to do with age, nothing to do with gender, anything like that, then a straightforward unfair dismissal is capped at 1 year's salary, and then it's got a further cap of about £90,000. With disability discrimination or any other elements of discrimination, it terrifies employers because there is no cap on what you recover. And I'll talk about some cases near the end of the talk. But you know, someone got £135,000. You know, it is not small sums of money when you're talking about discrimination. So it does terrify employers, and so it should, because they need to get it right. So like I said, let's look at disability discrimination first, and then we'll look more at reasonable adjustments, because I find that area of the reasonable adjustments, I think, is more practical probably on the day-to-day side. But all the disability discrimination legislation is designed to apply to and protect employees, workers, contractors, self-employed people. So if you're in a self-employed capacity, job applicants, and sometimes former employees. So that is very limited, but usually it's around when the references are provided. And I should say, you know, no one has to tell their employer or their potential employer that they're disabled. But if you don't tell them, they have a defence potentially in law. So you have to show that your employer knew or ought to reasonably have known that you were disabled. So I know, obviously, cerebral palsy shows and is demonstrated in loads of different ways. And it might be that sometimes it's obvious, like it's obvious there's a disability, and other times it may not be. And it's more a case of the employer's got to kind of have an idea, and that's whether you tell them or there's an indication of such. But if they have a defence that they weren't aware, then all the legislation of that protection isn't there for you. So there's got to be that knowledge on behalf of the employer. Yeah, Miriam.
Sorry, I keep interjecting.
No,
I
absolutely.
hope this is okay.
Absolutely.
So just from a point of view of disclosure,
Yeah.
At which point would you say that it would be sensible? Would you say it's at the interview stage or when you're offered a job stage?
Yeah, I mean, you can tell, you know, I'd love to sit here and say you could tell them at any time and it doesn't matter. But I know that isn't necessarily, that's the kind of legal point of view. Putting my practical hat on, I know it's not that easy sometimes. At the interview stage, I would definitely encourage you to ask for reasonable adjustments. So at that point, you do not need to disclose you've got a disability. All you are asking for is reasonable adjustments to be made. So that could be accessibility, and we'll go into a few more details, but it could be accessibility. It could be the way where the interview takes place. It could be that there's an assessment and you require some aids to help you with that assessment. So you can ask for reasonable adjustments without disclosing the disability, and employers are specifically told they should not be asking job applicants if they are disabled. They should ask if you will need a reasonable adjustment, but not that you're disabled. So at the interview stage, I was asked for the reasonable adjustments, but not disclose the disability necessarily. If you are offered the, sorry,
Sam. So just so if I went to a job interview, all I would need to reasonably say is, if I take this job, I will need reasonable adjustments.
You don't even need to say it on the basis of the job. So what you would do at that stage is say what you would need for that interview process. So you're taking one stage at a time.
So it's just about the interview.
Just about the interview and the assessment to get the job. Now,
Right.
It might be that you want to be a bit upfront. Like if you're saying, well, I could get this job, but actually there's part of the role that I just can't do without support. You might want to disclose that, but actually you might want to wait. You might want to see if actually you get to the stage of the job interview. And if you are offered the job then you could disclose the disability and the adjustments that you may need to undertake the role fully. I mean, I've seen job descriptions and person spec that have got, 3-4 pages list of duties, and it's just a bit of a catch-all. Actually, you can find out a bit more about the job in the interview. What is the day-to-day obligations and duties, and basically what you're going to have to do. And then you can properly assess whether that's something you can do with support and help, or whether it is such an essential point of the role that is not a suitable job for you. And I'll talk about what, we talk about, I've said the words reasonable adjustment about 15 billion times already, but it isn't an absolute duty. It is what is reasonable. If you're asking for adjustments that are just far and above what the employer can offer, then you haven't got, and the employers don't have to do everything. But there is a recognition, the bigger the organisation, the more obligation they've got to do things. So as to going back to the original question as to when to disclose, I would say ask for reasonable adjustments at the interview process. Find out more about the job. Do you know enough to be able to actually say what you need before the interview process? Probably not. And then if you are offered the role, you can then disclose the disability and discuss the reasonable adjustments that may need to be made. I think from my point of view, and obviously it is from a legal point of view, if the job is withdrawn at the interview, so, you get offered an interview, you disclose the disability and the reasonable adjustments, then all of a sudden the interview gets retracted. That's quite difficult to show that it's because of your disclosure.
Right. Ask,
Yeah.
You say that if it's a case of you suspect it's discrimination, disability, am I correct in saying the onus is on the employer or potential employer to prove that it isn't?
Yeah, the burden
correct?
does shift. There has to be a level of proof on your part, but the burden does then shift onto the employer to some extent. It's quite easy for an employer, I think, to get away with, and I say that, get away with withdrawing the job interview, saying, oh, we pulled it, we're going in a different direction with the role, it's not exactly what we thought of. Once they've offered you the role, if they're actually offering you the role, feel like during the interview process you've been a suitable candidate, I think it's much harder to then disclose a disability and then have the job offer retracted. So I think the employer will find it more difficult because of that shift of that burden on them to justifiably, without any discrimination, show that a job offer has been withdrawn for another reason.
I suppose the other thing that I'm thinking about in this post-COVID world, that a lot of things are going on Zoom or Teams or whatever, then it's quite possible for a person to be interviewed from shoulders up.
Absolutely.
And therefore physically or visually, you don't, it's not obvious if there is a disability that needs reasonable adjustments. Whereas obviously if you do a face-to-face interview, it will be much more obvious.
Yeah.
And I'm just curious, I suppose, but I think this is the long-term conundrum, isn't it, really?
Yeah, it is really difficult. I mean, I'd love to say early disclosure is the best way forward, but I think I'd be slightly misrepresenting things. And, from my point of view, it is easier to prove at a different stage. Once you've got the job offer, and if it was ever withdrawn, I think it is easier to prove, because we do everything really a bit on the balance of probability, what's more likely than not. And I think it is easy to prove a claim for disability discrimination if you've got the job offer in your hand, then you disclose what reasonable adjustments are needed to be in the workplace, because you've already kind of secured that next level. But it is tricky. It is tricky.
Can I ask a question?
Absolutely.
Sorry for jumping in. I'm just playing devil's advocate, and also have interviewed a lot of people for jobs in my time.
Forward. Yeah.
Would anybody have, in terms of ethical considerations, if you don't disclose your disability and you're going for a job that the employer feels that they can't support you with, is that, I'm just kind of seeing it, I'm trying to see it from their point of view in terms of
there's no, I mean,
their thoughts
obviously,
of your ability to do a job, particularly a physical type of job.
Yeah, I mean, you've got to properly assess whether you can do the essential elements of the role with support. Now, if you're not going to go for necessarily, in the same way I'm not going to go for certain jobs that are outside my skill set. I think you've got to be realistic and about what you can do, but it can, bearing in mind that support can be given. In terms of ethical, it sounds really awful, because I am obviously, integrity is one of our main values at Bark and Kirby, but it's very much a case of you don't have to worry about that.
Right.
It's for the employer to consider whether they can make the reasonable adjustments, and there's factors you take into account, which I'll talk through later. But it's not for you to necessarily worry, will they, won't they? Admittedly, it's a time factor. I appreciate you put your effort into the interview, you get your hopes up about the job, and then potentially it doesn't happen because they can't do everything that you need. But the onus is on them to do that. You can be full disclosure in terms of what you need. That's not necessarily disclosing your disability at that stage, but you could be honest, saying that, or as part of this role, my understanding is that there is, I'm trying to think of an example now, a specific chair. Let's say that a specific chair is required in order for you to feel comfortable. And I would need a specific chair in order to accommodate me. Well, that would be reasonable. Kind of what the role would entail. You can kind of guess what the chair is, but there's also that you shouldn't necessarily second guess everything, depending on what your employment experience is. I mean, you could be entering this as your first job where you need reasonable adjustments, or it might be a case of you've been in a similar environment and you know what kind of works. Yeah. So I am very much about the engagement with the employee, prospective employee and employee, and the employer. So if they work and engage together, so much happiness in the world, in the sense that there is that kind of real connected, joined up thinking as to what will actually help the person, rather than second guessing and getting it wrong, and then it's ineffective what adjustments may be in place. I hope that helps to some extent.
Amazing, thank you.
I mean, like I said, no one actually needs to tell their employer they're disabled even when they start work. But it does give you the kind of protection, I think, that would be sensible. I looked at kind of examples when you should, an employer could ask. It does mean, if they are asking you to prevent health and safety risks, that's considered reasonable. If they're worried about disability discrimination, they can ask you. And also when they do their kind of surveys to monitor the number of disabled people in the organisation. So they can ask. And if you are asked, you should disclose it, you shouldn't hide it, but there are limited circumstances in which they should do that, and ultimately it should be across the board. It shouldn't be that they're singling someone out in particular. If like a survey goes out, it's got to be to all the 100 employees, not just one individual employee that they suspect is disabled. Okay. So like I said, I mean, the law does protect people from indirect discrimination. So the definition is on the screen, but it's really less favourable treatment. So if you weren't disabled, you wouldn't be treated in that way. Okay. So that is direct discrimination. I see that probably more obviously. It's a bit easier to prove sometimes because it's specific instances, isolated events, things like that. Okay. There's some things going on in the chat that you're monitoring, aren't you? So I won't. That's fine. I won't know.
Chris, do you want to mention what you were talking about, Chris?
Which one? Sorry.
You talked about the recent case.
Oh, yeah, no, it's just there was a recent case just when we were talking about reasonable adjustments in interview where NHS Digital lost a discrimination case for not providing reasonable adjustments in interview for an autistic man, I think, which paid out about £20,000.
Yeah,
so
it was the way they processed information, and they asked for a reasonable adjustment, which I think would have been absolutely reasonable to have made given the size and the extent of the organisation. And they fell down on their recruitment process.
You say that. I work at the NHS. I'm a healthcare assistant, and to be fair to them, they are very, very good because I don't want that. I work in the theatres at the moment, but up until a few years ago, we got a reading unit. Now, I thought, okay, I'll go for this other job, but I wasn't quite sure. But if you actually fill a form in and you meet the essential criteria, and you then tick a box, you got a disability, you're guaranteed to interview. So that really is pretty fair. And they've been really, really good with adjustments as well. Excellent, actually.
That so makes me happy and really pleasing to hear. And, I don't want to say never work for a small organisation or a small employer, but when you've got a larger employer who has the resources and the funding there to support, it is much easier to request support and help. And being practical, it is easier because they know their obligations are higher. If you've got a one-man band who employs someone, I do think it is going to be more difficult to make adjustments and request those adjustments. And that, again, that's being honest with my experience. But when you say someone like the NHS, then that's great to hear because that's what they should be doing and that's what's expected of them. And they are simply compliant. Whilst I say that's really pleasing, it is what it is. That's what they should be doing. We should be sitting there being, oh, that's amazing, so grateful. That is that's what they should be. But I am grateful because that's your experience.
They do actually at times go above and beyond what they should do.
That's so good to hear. That's so good. I mean, the larger the organisation, as I said, it does help. It does definitely help. Okay, my slides seem to have suddenly gone. There we go. It's gone back one. There we go. So section 15 talks about discrimination arising from a disability. So another part of the Act, which means that someone's treated unfavourably. So not just less favourably, but unfavourably. But in this one, they can't show, the employer would be held kind of guilty. They can't show the treatment as a proportionate means to achieving a legitimate aim. That's a really tricky one. But essentially, an organisation may have a defence for this type of claim if they can justify their actions were proportionate. Really what I'm coming down to when I've looked into the kind of the background and is health and safety reasons. They can't do something because they're worried about the harm of being caused to others. But they'd have to show, there'd have to be kind of paper trail, I think, that they've really conducted that balancing exercise between the business needs and the discriminatory effect upon the individual to consider whether there's definitely, you know, they've been treated favourably or less favourably or unfavourably. Okay. So indirect discrimination is something we touched on before, this provision, criterion or practice. And like I said, it's more to do with policies, processes and practices in the workplace. So this is when it's not just an individual thing, it's just putting generally a class of person at a disadvantage who shares the same characteristics as yourself. In this case, we're talking about disability. Also, we look at harassment. So this is when someone has, it relates specifically to the protected characteristic. So it's got to be in relation to the disability. So there's been unwanted conduct. It feels like your dignity is being violated and it's created an intimidating, hostile, degrading, humiliating and offensive environment. I often find that if there's discrimination that's taken place, this can be quite easily connected. Because actually being discriminated is really intimidating and hostile and you don't often want to work there. And victimisation usually falls in line with harassment, but it specifically just says about the fact that you feel victimised. Okay. So the Equality Act is there, as I said, for protection. And I do, unfortunately, deal with disability discrimination cases. One that came in this week that I'm assisting with is someone who is, well, I'm seeing quite a lot of neurodiversity arguments now where someone is neurodiverse, this person had autism, and they were on a call centre having to deal with a number of calls. They had a target that wasn't adjusted. Things like that. So I do see it, and we're engaging with the employer to exit her out of the business for a compensation package. Okay, so what I would say, oh yeah,
can I ask you one? So a couple of things that happened in my job history that I'm just. So I was a speech and language therapist. I used to work in a clinic. I was just thinking about health and safety, and they brought in a new policy that the clinic doors needed to be locked at 5 o'clock to stop people coming into the building that they didn't want to come in. But that meant that I couldn't get out of the building because I couldn't open there were electric doors that were very heavy.
Yeah.
Which therefore meant that I couldn't work in that clinic where I was doing my job.
Yeah.
Is that, I mean, I won't go into, and at the time I was young and naive and didn't really do very much about it, but I'm just reflecting on your help. Would that be an example of health and, you know, where they have to kind of?
Yeah, I mean, it could be, because it could be that the decision to, if you didn't close those doors, the risk that there may be harm caused by members of the public, for example, are at risk. I think there would be a way around. There would be key cards where you could open that door, but no one can come in, but you can get out. And that feels fairly reasonable. It is difficult to say. I mean, with disability discrimination claims, as on the slide, you've got a very limited period of time to do anything about it.
Yeah.
You've got 3 months less than 1 day from the date of the problem you experience at work. Now, if the discrimination is taking over a period of time, the time limit runs at the end, like the last incident, and we argue it's continuing. But you have got to join up those instances. So if they're kind of isolated and unconnected instances, then technically the time limit might run from each one. So you might be time barred from doing anything about those. Tribunal can accept claims at a time, but it's not easy. We've done it recently on disability discrimination claim. It's cost more money for us to do it, but we have done it and we've got into the tribunal out of time. So it's possible. Chris, I'm conscious, I can see that you've got your hand raised.
I was just going to say if that happened in my trust, then we would argue that that was not reasonable and we'd want something put in place for Emma to be able to work in that clinic still.
I struggle that letting people in and letting people out are two different things, aren't there?
Yeah.
And there's a lot of doors that can do fancy pants things.
I think the one that would cover that would be a safe means of access and egress, isn't it, really?
Yeah, I think just to clarify, this was a long time ago. I was just trying to think what health and safety things would would
I have an
Yeah.
example if you want that we've got at the minute, which is where one of our buildings, there's a problem with the fire alarm and someone who is deaf works there and they can't work alone until we've sorted out our system. So yeah, they can't be alone in that building now,
Yeah.
which is obviously a little discriminatory to them because they can't just stay behind and finish stuff. But yeah, it's a
But
temporary
you
thing.
feel it's a
Safety.
short term, hopefully. It's a short term issue that's going to be resolved. It's for now. And whilst it's not ideal, hopefully that will get sorted. Now, if that was a long term, I think that wouldn't be reasonable.
Yeah, they at the visual
Mm.
system when they were by because they have flashing light. If it sounds if an employee is deaf and the fire alarm sounds in a place and they know they were there, then they need to fit a sort of visual alarm system, don't they?
And there's things out there, you know, I've seen
Yeah.
vibrating kind of things that go on the
Yeah.
desk if they it always like the things you get at like Frankie's and Benny's when your table's ready. It's like it's one of those things. So I've seen that connected with fire alarms. So yeah, I mean, I think the thing is I do see claims and it's sad because people don't always understand the law. As I said, the smaller organizations are often, but the one I was talking about today, it's a massive company. Absolute massive, and they are not realizing the impact their policies and their targets are having on an individual. And she's raised grievances, they've not been properly dealt with, they've said there's a staffing issue, not really good enough. You know, it is individual cases, but there are things you can do. I mean, like I said, it might be that we're time limited and therefore you want to put in a claim. You can engage ACAS, which is kind of an early conciliation opportunity. But gets to a point where sometimes we do lodge the ET1 claim form. I tend to do a lot of work before we get to that stage. So it's quite condensed in the period of time beforehand. Sarah, I can see you've got your hand up.
Yeah, what do you class as reasonable adjustments? Because there's a lot of disabled people that can work but need help with like going to the toilet or say they need assistance with PA or like to help them get the food. And I mean, what I went for a job interview to DWP and I said, well, what happens if I need the loo or I need personal care in my loo? And they said, well, we don't support you with that.
I mean, given the organisation we're talking about,
yes, that's naughty.
I would struggle to think that something can't be done. I mean, I'm going to go on to reasonable adjustments, and I am more than happy to go into any detail that you want to at that point, Sarah, because there is a proactive duty on employers to make adjustments. So I've put on the slide the kind of requirements that are being made. And yes, Sarah, feel free to dive into further in, but we'll crack on with reasonable adjustments because
can I just can I just mention this really highlights the importance of being in a trade union, even if you are not employed at the moment. You can still be a member of a trade union.
Yeah, I mean, I work, by the time I've got involved, trade union has normally been involved, and they've kind of exhausted all the opportunities they've got. Now, you know, but they are really supportive often to my clients up into that stage. So I've also worked closely with union reps in the past. We used to, going back a long time ago before the personal injury law changed, we used to have a relationship with the union USDOR. So I used to work really closely with them as part of the personal injury side of things. So yeah, I know I can see the work that union's done, I have seen firsthand has been excellent. So it does give you a support network. I think that's what it does. So yeah, so section 20, as I said, this kind of proactive duty to make adjustments. It's a positive proactive duty to take steps to remove and reduce the obstacles in the way of disabled workers. So it's the moment the disabled worker tells them they're applying for the job, as I said, when they apply for a job and when they work for the employer, there is we were kind of discussing earlier about the set recruitment processes. There is no actual legal set recruitment processes, so which is a good thing in some ways, because that means it can be adjusted and be made more favourable. And they've got to follow a fair and non-discriminatory process throughout the whole recruitment process. And I think the thing is, if you're an agency worker, contract worker, it's all relevant. You still get that protection. And as I said, you know, in your application, going back to that type of situation, setting out your skills and experience that make you the right person for the role doesn't mean you need to focus on your condition. And like I said, you don't have to answer questions about your disability at this stage, but the duty is also not anticipatory. So it's not something that if you don't tell them you need reasonable adjustments for the interview, you can't criticise them for not making them. They won't make adjustments on the off chance that a disabled person might go for the job. Okay, now I encourage as a standard practice for employers that they put on their forms, do you need anything to assist you? So I undertook some interviews recently, and I got a notification that someone said they actually disclosed the fact they had dyslexia, and that during the interview process they might need time to process my questions before answering. Absolutely fine, no worries about that at all. So it wasn't asking if they're disabled, it's asking for the reasonable adjustments. And if you have told them you need reasonable adjustments, the employer becomes aware of the disability, or you've specifically asked for certain adjustments, they've got to do them. Okay, and I say as reasonable. Now, what may be reasonable at the interview stage may be different to what's interview when you're employed or you've been there a long time. Okay, so what may be at the interview stage is reasonable, maybe a slightly higher threshold, to put it that way. So it might be that, okay, asking for certain things might be too much because it's a one-off thing and it's too much to ask for that on that occasion. But, you know, you've been there for 15 years, your condition is deteriorating whereby you need help. That, I would say, you've got a lower threshold to meet in terms of what might be reasonable. Okay. So, yeah, like I said, it might be when you disclose things and when you ask for reasonable adjustments can be throughout the whole employment. So it can be at the interview process, it can be when you get the job offer, it could be when you're moving into a new role or new setting, new location within the organisation. It might be if you receive a new diagnosis or your condition changes, or it might be that you want to disclose it when something happens at a formal review or an appraisal, when there's something's being discussed. I think when looking at reasonable adjustments, one of the key things from my point of view, I've looked at quite a few, is the Equality Human Rights Commission, so the EHRC. They're designed to promote and monitor human rights. They have an employment statutory code of practice, and I refer employers to them very regularly, because they have a kind of strapline that employers should do all that can reasonably expected to do. So they need to find out information, make inquiries, bearing in mind kind of issues of dignity and privacy, and ensuring personal information is all dealt with confidentially. But there is a really good code of practice on there as to what I would recommend employers do. Accordingly, on the flip side, you can look at it and think, have they done that? And if they haven't, whether they should have. Okay. So yeah, I think the failure to comply with their duty causes a significant amount of problems. Okay. Yeah, so this kind of goes on to what does reasonable mean? I've said the word about, as I said, 1,000 times during the talk already, but it depends. And I know that's such a cop-out for a lawyer, but it does depend. There's not an absolute duty on the employer to do everything possible to ensure a disabled worker can undertake the role. But what is reasonable will depend on the circumstance of each individual case. There's various factors that influence it, which we'll go through. But the test of what is reasonable is an objective one. And it's not simply a matter of what you personally think is reasonable. And that's ultimately why things end up in the tribunal, because they disagree. And that tribunal is there to look at a more objective view as to what is reasonable. So when considering what is reasonable, these are kind of the main factors that I would consider. Okay. Whether it's practical, you know, is the adjustment, can they actually make it? Will it be effective? Will it effectively overcome the barrier in your way or reduce the disadvantage? Does the employer have the funds to pay for it, or is there financial support available? Do they have the resources to arrange implementation of the adjustment? And also the consideration of, will the adjustment have an adverse impact on the health and safety? So again, we go back to that balancing exercise. And I said it already, but I do think that looking at the case law and what we see, a significant factor is the employer, the size and extent of who the employer is. Tribunal expect more from larger organisations. It is just what is there. But when it comes to cost and resources, there is another thing to consider, and that's the government's access to work scheme. Just because they can't maybe fund it, it might be that support's available through that, and therefore that would be considered effective from a cost point of view. I mean, I think different people need different changes, and even if they've got similar impairments on the face of it, I think it's all about engagement. So the employer may see someone, you know, someone's got cerebral palsy, and they think they have an assumption as to what that means for that person. And they may have no idea. Everyone has different symptoms, and what symptoms are individual to you, you need to communicate that with them. And there is that kind of joined up thinking and engagement with them to allow your employer to understand your condition and the additional support that they could provide to enable you to do the role. So you need that assessment, you need that engagement. And I'm very mindful of the mindset that they need to help you in the best way they possibly can. I think it's important, as I said, that you do notify your employer early on, because then that puts them on the hook for their obligations. But you need to engage with them. Now, I'll talk in a bit about kind of other factors to consider with that. But I think when you are thinking about what you need, these are the three questions that I kind of think are relevant. Do you need to change how things are done? You know, the practices, the way you go into work, the way you access your work, the way that your work is delivered to you, tasks are communicated. So how things are done day to day. Physically, obviously, Sarah mentioned earlier about kind of the access to the kind of hygiene side of things. You know, can you physically change the workplace? It might be, as I once worked in a listed building in Queen Square, that sometimes that's not possible. There might be ways around it, but sometimes the workplace can't be changed. How have we got 5 offices around Bristol and South Gloss? That someone could work at another office. You know, it's possible. Or do you need extra equipment or someone to assist you in some way? Is it a case of when someone's assigned task, actually someone needs to sit down with you and go through that, do a priority list, things like that. So it's so individual in terms of what you need, but you are aware of yourself and your own condition more than anyone. And therefore, you may have an excellent idea already of what adjustments will work best for you. And so there is that kind of onus on you to communicate that. Okay, so some adjustments may be really simple and effective, sorry, you know, like a keyboard, a special keyboard, a ramp, a policy whereby walkways are kept clear so it's wide enough for people to navigate aids what they're using. You know, it's things like that which are not rocket science, but really make a difference. Touched on earlier, change of working patterns and hours. Flexible working is something that, I mean, I personally do because of childcare arrangements. And at Barking and Kirby, I think something like 80% of our workforce work flexibly or agile. They don't do the 9 till 5:15. So we work really hard on making sure we've got flexible working arrangements. Now, that is now a day one request you can make. So this is not something where you had to wait 26 weeks before you could make a request to do it. To be honest, employers didn't used to wait that long anyway. But you can now make a day one request to make a flexible working arrangement. That could be, it's not just shifting hours. I had a client that said, could she work an earlier shift and leave earlier because she found it very overwhelming on the public transport. In terms of it was too busy to getting in for 9 a.m. She couldn't sit down. That made her feel very anxious, etc. So she changed her hours from a 7 till 3. So therefore, she was missing the kind of high end on the traffic on the bus. It could be other reasonable adjustments. Could be like a phased return after a period of sick leave to allow you to adjust into the role. We discussed earlier modifying sickness triggers. That's something I see fairly regularly. It could be like, you know, obviously we're working at home and in the workplace, and most people are just thinking, oh, just get a backpack on your back to carry your laptop. It might be that a trolley bag's more suitable, some other kind of, or that actually the laptop stays in the office and there's another laptop when you go home. You know, for the laptop's probably about 500 quid or something. You know, it would be reasonable to have that kind of facility in place for some employers. Also, modifying performance targets. I hit on it earlier when I was talking about one of my clients, but if you've got performance targets in place and there is a failing of targets, then it could be that it's reasonable to modify them, given your disability. Okay, but what is reasonable? It varies. It varies on case by case, but it can be like these things. So it could be actually more favourable compared to other people. Like, people are always worried about almost positive discrimination. You know, I can't do that because everyone else will get annoyed. Oh, it doesn't matter. You know, it can be more favourable and it can favour the disabled person. I think the adjustment must be effective. The amount of times where the employer has just steamrolled ahead and done something can actually not really address the barrier or the disadvantage the disabled working is facing. And then it doesn't have there's no point to it. It might be that so many little things, so several different adjustments can be done together in combination, and that might help things. It might be that, you know, it's the more likely it's considered reasonable, the less difficult it is, I would say. You know, if it's small things, it might be it's more justifiable that it's reasonable. Okay, if the adjustment costs little or nothing and it's not that disruptive, again, I struggle to think that wouldn't be considered reasonable. And I've said it before, the size and resource of the organisation is relevant. You know, if it costs more, then the larger employer will be able to suck that up in a different way.
Can I ask a
yeah.
question here, Samantha?
Absolutely.
Whose responsibility is it to think about how to problem solve the problem?
Yeah.
So, because
it shouldn't be all on you. It shouldn't be all on you. But I also feel that employers, they try and do things that help that may not help. Therefore, and as I said earlier, you know yourself and you know your condition. It might be that in a previous workplace you did X and that you can help the employer do X by sharing that information with them. So the onus and the obligation and the duty is absolutely on the employer. But there has been criticism in the past I've seen in case law where the employee has not engaged and not been helpful. So I think it's the engagement of the two together. So it's not for you to say, I want X, Y, and Z, you've got to do all this. But you can say, this is happening, I think this will help.
What happens, sorry, if it's the other way around, because that's what I've had a couple of, in that you know what the problem is, you haven't thought through what the answer could be. Like, often, I mean, I've had people talk to me and saying, I know what the problem is, and I've talked to the employer about the issue, and they'll say to me, well, how are we going to solve this? And I don't know how to solve it. I just know that these are difficult.
Yeah.
How does that work? In the other way around?
Yeah, the employer, so there are resources available to them in the sense of occupational health. Right. So if you don't know, they don't know, we know there's an issue, we think it can be overcomeable, but we're not quite sure what to do. There are occupational health could be instructed, and that would be reasonable to expect an employer to do, to give us a guidance and a steer as to what might be reasonable. If the occupational health goes, oh, also I'm not entirely sure, There is also a vocational rehabilitation advisors you can instruct. Again, the larger the organisation, the more access they'll have to those kind of resources. But they give, I mean, I've seen a couple of reports from them. I mean, they are basically telling you what you can do. So if you're explaining the problem, they usually can find out ways. Like I said, the ECHCR guide is really good to have a look at, because it might be that you go on there and go, oh yeah, I hadn't thought of that. And that gives a really good list of what adjustments might be made. But if you are worried that, well, I don't really know, the employer doesn't seem to really know, an encouragement to engage occupational health or vocational rehabilitation advisors is a really sensible avenue to explore. Okay, and Sarah, have you got your hand up? Sorry. Oh, are you on mute?
I was working at a voluntary service for 14 years. Anyway, I've been working there voluntary, and the lift broke, so I couldn't get to the office because I couldn't get upstairs, and because it was a charity, and it was said it was going to cost £10,000. So I said to them, and so they said to me, so I couldn't go and do my work for a few weeks. So, and then they said to me, they gave me an email saying they would like it back, but, and they said, well, how can I help you? So I just said, could you not bring the phone system downstairs? Yeah. No, we can't. And that was it. I couldn't do my job anymore.
Yeah, so I mean, there are the formal kind of avenues. Obviously, I deal with it when the proverbial sometimes hits the fan, as I said earlier, but a grievance is the kind of formal process in which you raise a complaint. So it's all very well talking to kind of line manager or maybe just a colleague about this isn't right, I'm not sure this is the right thing they should be doing. And then a formal grievance whereby, you know, it's got to be properly investigated and dealt with, or it should be anyway. They've got to follow an ACAS kind of code of practice, code of conduct type thing with grievances. And a grievance can be in a really effective way to remedy a situation. So it might be sorry?
Well, it was the Citizens Advice Bureau that I had the grievance.
I should have known better.
But anyway, I left under a dispute.
Yeah.
And I was just really annoyed with them.
Not surprised.
Because I've been there for like 14 years, and this is how they treat me, and so I left on a sour note.
It's difficult. I mean, voluntary work it has sometimes there is a difference between volunteers and workers. There is sometimes kind of distinguishing factors depending on the situation. I would say that, you know, volunteers sometimes can delve out of workplaces, and therefore the obligation on an employer might be less so if you're only working there one day in 6 months. Do you see what I mean? Like, there wouldn't be necessarily the obligation to do everything in the same way. If you've been there, do you say so, 4 years?
No, 14 years.
Oh, 14, oh my goodness, sorry, 14 years working regularly with the organisation, then I question the obligation. So like I said, a grievance can be a really good way to address the issue and seek a remedy, because it's looked at by more senior people, essentially, and it's a formal record.
Well, they did. They just said, we can't afford the amount of at the moment, so I was just in limbo.
But like I said, the access to work, you know, there's funding options. Also, you look at alternative. Okay, they can't afford £10,000 for the lift, but why can't they bring the telephone systems down? Why can't they redirect a phone? So, you know, the lower, you know, you're talking about, okay, £10,000 for a lift. Okay, that might be a bit onerous at the moment. Maybe that isn't reasonable for a charity. But there's also certain things. But like I said, volunteers do have less rights. than a worker, but it does depend on the individual circumstances. So it's not absolutely kind of one or the other. Like I said, what is reasonable in one situation may differ to what is reasonable in another one. Like I said, if the amount of time you've worked there, if you can't be redeployed, sometimes redeployment is a really good way around things, as long as they're kind of everyone's signing up to it. Like I said, the access to work, I struggle sometimes with funding side of arguments because there is the opportunity to look at that. But yeah, it's really difficult, and I imagine there are very much a lot of individual cases that may take place. Like I said, there's loads of kind of examples on the EHRC. Discuss it with your employer, and as I said, if uncertain, rely on experts. You know, like I said, the kind of occupational health rehabilitation advisors are really good to get on board with. It's very much a case, you know, there is, you know, let's be honest, there are reasons where people can be dismissed for fairly, and one of those reasons can be capability. So if someone thinks, the employer thinks you are no longer capable of doing the role, they could potentially take you down a capability process where they are essentially managing you out of the company. So you need to raise these arguments at these stages, because you could have a case for disability discrimination because they're not considering reasonable adjustments when they're taking you down a capability route. Okay. Just to say on the access to work scheme, another thing I was just refreshing my memory is that you can get a grant potentially depending on how it works and what it's for. And my understanding is that it's not means tested, it doesn't affect any other benefits, and you don't necessarily have to pay it back. Sometimes the employer might pay up front, but then they get refunded. So it works in different ways. Okay. And I thought people, I don't know, we've talked a few about practical examples. So I'm really, thank you for sharing, because it makes it feel much more real than just me going, oh, they're meant to do this and do that. So I'm hoping these cases, kind of real life case examples, also provide a bit more of a reality on the situation. So there's a case, Northumberland, Tyne and Wear NHS, and again, we're talking about a large organisation. So in this one, the claimant suffered ME, kind of chronic fatigue symptoms. They've been there over 15 years, and they had sickness absences, more so than their other employees. And they originally adjusted the sickness policy in the disabled workers' favour. They were like, yeah, no, that's fine, good working, just offer more, let's reduce the triggers. But then all of a sudden, they just withdrew that kind of more favourable treatment. The claimant was unable to meet the attendance requirements, and she was eventually dismissed on the grounds of capability. So the claimant brought proceedings in relation to direct discrimination and failure to make reasonable adjustments, i.e. the decision to remove the adjustment that was put in there for her. And, you know, you've got to think, if it was reasonable then and then they withdrew it, is it not reasonable still? All the complaints were upheld by the employment tribunal, and compensation was awarded. So she proved there was a direct discrimination claim, and she proved there was a failure to make reasonable adjustments. You know, it's very tricky for an employer to say it wasn't reasonable to do it when we were already doing it and then removed it. Okay. Case of Bronson and Colo. So this was limited. So it's actually, let me just check. This was the one. So it's actually part of London Borough Council. So it's a bigger organisation than it first appears to be. So this person was awarded just over £134,000 in compensation. So the employer had engaged occupational health. And like I said, this is one of the things I would encourage people to do if they're not sure what to do. Occupational health were great. Then the employer decided to ignore everything that was said. And failed to make any of the recommended safety adjustment, including like a lumbar support. It was a guy with a bad back. His back got worse, experienced further problems. And, you know, that was said to be a consequence of them failing to do these health and safety recommendations. And then they were giving him tasks that he wasn't trained to do. So he had not only a disability discrimination claim, the failure to make reasonable adjustments, but he also then had a personal injury claim against them because of their failure to do loads of things. So as soon as, I mean, to be honest with you, as soon as occupational health recommendations are made, as long as they are relatively reasonable, and occupational health tend to consider that when they're making the recommendations. And, you know, I don't make any excuses for the fact they are instructed by the employer. So, you know, there is an element of maybe favoritism for the employer. So when they're doing it, they're saying, this is reasonable for you to do. If they don't follow it, like the employer is seriously got, I've got serious concerns from an employer point of view. If my client is recommended, my employer client has been recommended to do something and they don't do it, I am worried. So that's a clear indication that something's up. If occupational health are suggesting something and they don't do it in a promptly and timely fashion. And the other thing with, sorry, yeah.
Can I ask you, Samantha, then, just going back to that, if you have disclosed that you have a disability and you need reasonable adjustments and they offer you a job, should you then be asking to have a meeting with health and safety so that they can then document what your needs are within those reasonable adjustments as a form of evidence that there's the process that has been followed?
Yeah, I mean, from an employer's point of view, it gives them a bit of extra protection if they are arranging those kind of meetings to have that engagement, to show that actually they are trying to accommodate and make those reasonable adjustments. If you don't feel your employer is, you can ask for it. Say, is there someone I should be meeting? Is there a health and safety body? Is there, you know, is occupational health sensible to get involved at this point? And they may say no, and that's fine. And, you know, you might put reasonable adjustments in place that work for a time, and then new symptoms might come, conditions may deteriorate, and then it needs to be re-looked at and re-examined. So this isn't something that, oh, it's working now, it's going to work forever. It, you know, having those kind of reviews. I mean, we have like monthly one-to-ones, and most organizations do now. It's having those review checks and making sure that everything is still working, and if it's not, addressing it. And it might be that that's a meeting with HR, health and safety, or occupational health, or it might be just your line manager. It depends.
Becky has written in the chat, what if occupational health refuse to see someone, or you can only see occupational health if your manager refers and they refuse to refer?
I would really put it in writing as to, I understand that you are refusing to refer me to occupational health, and I'd like to understand the reasons behind that. Get that in writing. It's all very well verbally, you know, and if they then call you, you can go, what I often recommend to clients is that if there's a constant, you are emailing and then they are picking up the phone, kind of warning bells are in my head as to why they're not putting anything in writing. So I often would follow that up with an email to say, thank you so much for calling me today. My understanding is X, Y, and Z. Please let me know if there's any concerns that you have around this, you know. So recording it in writing, putting it back to them. I mean, I've relied on people's diaries entries in terms of what was reported at the time, kind of contemporary records. It's all very well, you know, it's happening to you. So you tend to have a much better recollection of the situation than some manager who's got 50 employees dealing with 50 employees. But I do tend to recommend you kind of pop that back in writing. I think people, if you have recommended, if you are asking for occupational health and they're saying no, again, I think there's slight dodgy grounds. I would consider raising a grievance in order to address that more formally.
Brilliant, thank you.
There's a few people with their hands up. If I touch on that, Chris.
Sorry, I missed the button there. Yeah, just to add to that, there's not a requirement to go to occupational health to get reasonable adjustments. So
you don't have to, no.
Yeah. So the legal standard, I think, for like officially asking for reasonable adjustments is you literally just have to ask for it in a meeting, and that is your request there. So if they are not sending you to occupational health, you're not blocked.
No, absolutely. Yeah, no, that's a really good point. Thanks, Chris. I mean, I think, yeah, there's no legal obligation to get occupational health involved, but if you can't figure out what best to do, and people are just not really wondering, you know, they're wondering, they think something could be done, not sure what, it's useful to rely on experts, but no, there's no obligation on them or you to include occupational health. It just might assist the situation sometimes when there's a bit of a stalemate. Yeah. Sarah. Oh.
Me?
Yeah.
No, as I said before, I tried getting work, and I said as soon as the interview's over, I got a rejection. It's like they can give you a interview, but they can't give you that job. They don't have to. Is that right?
Yeah, if I'm honest, that is. The difficulty is proof. You've got to prove it was because of the disability and not anything else. And it's very easy, I think, for employers at that stage to say it was something else. And it is difficult.
And also, with the new legislation with PIP and that, will there be a much more influence of employers and employees wanting to go back to work after long periods of sickness and that? Will employers find that a lot more expensive because a lot more people have to have more reasonable adjustments to stay in work?
Yeah, it's difficult to say at this stage. I suppose we're kind of early days, but I think with the way the world is at the moment with hybrid working, a lot more working from home, remote working, and different ways to use technology, it's almost easier than ever to support people. So
but then you've got isolation, haven't you?
You have, and that I did a few talks during COVID about hybrid working, returning to work in the Great Resignation and all that kind of stuff I did at that time. And it really it's such a balancing act. I don't think there's a right answer still at the moment. It's down to the individual, it's down to the organisation. But I don't necessarily think employers are going to find it's such a hassle to accommodate disabled workers. I don't think there's so much strength, skill set, and attributes they can bring to roles that are essential to the role that can be accommodated. Yeah. Emma, you got your hand up.
Yeah, sorry, I just wanted to pick up on the occupational health. Just having worked for an employee that says that they have to follow what occupational health says to the letter of the law, and had experiences with other people that occupational health, almost rather than being a support, becomes a fearful place to be, in terms of the feeling that they're working with the employer, or using that as a reason why you can't do X, Y, and Z.
Yeah, well, I think Chris picked up on that point, and I think that was really useful. So thank you for that, because just because they don't say it doesn't mean it's reasonable.
But what happens if it's the other way round? For example, if occupational health would say, we don't think that person should do this, but you feel like you can do that, then the organisations that I've worked for have always seen occupation as the letter of the law, but it sounds like they aren't. It is.
No, I mean, it's guidance. It's not just, I mean, I know I talked about it, is the employer is at risk if the occupational health recommends something and they don't do it. Now, but that does depend on the size and extent of the employer and what is reasonable. That's still, it still has that test of reasonableness. Flipping it on its head and occupational health don't recommend it, that doesn't still negate the reasonable of what your request is. And if it's saying they can't do that, but you're saying you can do that, I mean, I've had people produce GP evidence to say this isn't a problem, to kind of counteract occupational health evidence. So I know some people are a bit hesitant, and yeah, like I said, I make no qualms about the fact that occupational health have been instructed by your employer, and there's no getting around that. But I have also had really supportive GPs who have helped in cases such as that.
Yeah, I think it's been my experience supporting some other people that it's felt that you go and see an occupational health doctor on a one-off, and how can they possibly understand what you can and can't do, and they're making judgments on a day that they see you, and I just worry sometimes about that.
I mean, like I said, GP evidence I've used previously to kind of say no, that's not possible. Sorry, I interrupted some of them.
Doesn't it occupational health say you can't do that? Aren't they under obligation to show why you can't do that?
It should be justified and reasoned.
Yes, they just can't say no, you can't do it. They've got to give a reason, haven't they?
Yeah. Also,
Yeah.
most of the time you get to see the occupational health report before it's disclosed to the employer.
Mhm.
That's something that I would recommend that you do. Okay. Is it Victor? I think I've got your hand up.
Yeah, that's me. Hello. There is one thing I tend to get when I go for an interview, and the afterwards, 9 times out of 10, it's the excuse that I didn't get it was I don't have the experience. And 9 times out of 10, I just tend to accept that as a generic answer. But at the same time, you've got to think, you've had my CV, you know what my experience is.
Yeah.
So
Yeah,
why?
you can challenge it. I have had people who have challenged it before. I suppose the easy get out from the employers, it's compared to other candidates that they interviewed.
Yeah,
That's the easy get out. But they, you know, they're not saying that, and therefore you can absolutely challenge it. I've had so I was acting for an employer who the applicant didn't even get an interview actually, and it nothing to do with disability. It was just they didn't like it, so they requested. They did a data subject access request, which is a whole nother topic. But they were able to get interview notes or consideration about what criteria they applied, and sometimes that could be quite useful to understand. But sometimes they destroy it, so it does depend of what kind of employer it is.
fair
Okay.
enough.
Yeah. Yeah, you're like, well, you already know, you've seen my CV, you know what experience I've got. Don't interview me then. Yeah, I hear you. Okay, I'll just go on to the last couple of cases, and we'll any further questions. So there is also a case, the Ryan Walker case. This isn't actually a reported case. It's settled out of court, out of tribunal, but it was in the media, and I thought it was a useful one. So this was a man with cerebral palsy was received £25,000 as compensation after alleging his job had changed, and that he was told by his employer to not play the disability card. So Ryan Walker had worked as a sales assistant at Home Bargains in 2017 and told the firm he could manage his disability by taking on a certain role that kept him mobile. It was actually, he initially was asked to stack shelves, that kept him active and mobile. But then the supervisor who joined, who asked him to work on checkout, and work extended hours on checkout, which meant he was sat down and not able to kind of keep mobile and keep moving. So he said, you know, I'm happy to help out on checkouts, but I can only do it for a short period of time. I need to move around. And then when he explained that, he was told not to use the disabled disability card, which is just shocking. And like I said, there was no judgment, there was no judge comments, but he said, you know, I was made to feel unwanted. There was a failure to make reasonable adjustments. He contacted the company's wellbeing team, he lodged a complaint, and he later resigned. But like I said, Home Bargains settled the case by way of a compromise agreement, settlement agreement, which I see very regularly, and he was awarded £25,000. So that isn't something that suggests some innocence there. And finally, the case of Holford's. So that, again, a recent case. It was November last year. I thought it was £25,000 again. I checked the figure. I was like, oh, I've just had £25,000 on that one. But he disclosed he had cerebral palsy during the interview, explained that he struggled with some tasks, such as changing tyres. His condition affected his left side, so producing weaknesses in his left leg and arm, limited his ability to handle heavy products. Unfortunately, his condition deteriorated and his hip also became inflamed, and also his ankle bones, which made weight bearing quite painful. He had to use a crutch. So he ended up having to have quite a few days off work, time off for appointments. Halfords did conduct a series of risk assessments to enable them to make reasonable adjustments. But they said the tribunal found that, and I'll just read this, the only adjustments that had been implemented to mitigate the claimant's disability were improvised and at best sporadic. So basically they risk assessed it, thought about it, and then really didn't implement it to any great extent. So, for instance, they limit standing time, which caused pain. So the employee used a stool from the tea room. That was just kind of an easy measure that was put in place, but sometimes the stool wasn't available. He had sufficient time to take breaks, but the breaks he was given were inconsistent and rarely happened. So they were making these recommendations, but not kind of doing anything about them. And also, in their sickness policy, they said that, you know, you had a return to work interview every time you had a period of sickness. But during the whole kind of couple of years, they'd only had one return to work interview. And then the employer was issued a record of improvement, which said he needed to make a concerted effort to improve his attendance to 100%. He was invited to a disciplinary meeting, and then he was alleged gross misconduct against him for failing to identify a missing wheel bolt during an MOT. So he received a final written warning. So there's a whole host of things you can tell. He then submitted a grievance about the attendance warning, the fact they failed to implement the risk assessments and the disciplinary process. Grievance said dismissed on all 3 points. He appealed and said, okay, yeah, we didn't really do what we said we did, but actually everything's fine. And he resigned and claimed constructive dismissal and disability discrimination. Now, the two are often intertwined. Constructive dismissal is where you feel essentially forced out. You feel your role's untenable, you can't possibly work with these people again, and you can't do the job you were employed to do. So that's constructive dismissal. So following the hearing, the employment did say that actually the harassment and victimisation claims they didn't accept, but they found that the claims for discriminating arising from a disability and a failure to make reasonable adjustments were both well-founded and succeeded. So we got money for compensation, including an injury to feelings award, which you can get in discrimination cases. So it was commented that by the judge, the question of what constitutes a reasonable adjustment is not defined in the Equality Act, and it is an area for which many employers struggle. There are a number of factors which the tribunal will take into account in determining reasonableness, but the list is not exhaustive and each case is examined on its own particular circumstances. If the company failed to implement adjustments which were identified in its own risk assessment, they would need to have made very strong cases as to why they were not deemed reasonable. Clearly, the tribunal wasn't satisfied that they had. So yeah. You know, as I said, if there's a disagreement as to whether an adjustment is reasonable or not, then sometimes it's only the tribunal that can decide. So there's that kind of issue. And I remember there was something, Miriam, that we spoke about that I just wanted to tag on the end, really, about equality and diversity policy. So, you know, 99.99% of employers do tend to have one, but there isn't a legal obligation or requirement for companies to share it. But you can always request it, and it should be part of their normal policies. And if they don't have it, I'd be surprised. Oh, yeah. So that is that. I mean, I think, let me just get that. I mean, as I said, I've taken kind of questions throughout. Oh, why is that?
Absolutely.
But if there are any questions, then I'm more than happy to answer any more.
Perhaps if you stop sharing, we can.
Yes, absolutely. There we go.
With anybody that wants to ask a question. But if not, I would love to say thank you so very much for coming. I have learnt a lot, a great deal actually. It's been really, really useful.